Please be seated. Good morning.
Good morning. As the court may be aware, in order to get from where we are until up here requires an escort and a fair bit of logistical support.
Fine. Is Mr. O'Mara on his way?
I'm sorry?
Is Mr. O'Mara on his way?
I don't believe so. I think he's somewhere else working on his closing argument.
So is he not going to be attending the charge conference?
That's my understanding.
Okay, then you're ready to proceed? If you
Yes.
need a minute, that's fine.
Thank you. Instructions put within a larger packet that may be of some assistance as we go through these. There aren't a lot of special instructions that we are proposing, but for example, in the larger set of instructions, I, just as a word processing issue, put proper names in the locations of where the individuals were referenced by defendant, for example. And as this is a work in progress, of course, I can't make all the decisions unilaterally. This has been a work in progress that requires me to have consulted, which I have, with Mark O'Mara, of course, and Mr. Zimmerman, who has not yet been fully brought up to speed on what we're proposing. I got some additional instructions from Mr. Manti early this morning, and I responded recently. So we're still sort of catching up. But I know that we have 3 or 4 hours.
Yeah, we
if
have
need it.
time, so I can make a suggestion that I would like Mr. Zimmerman to have a copy of both sets of proposed instructions so he could follow along, and to afford the attorneys another opportunity to try to work some of those differences out that are minor differences, for instance, the names being injected. Mr. Manti, do you have that information on your computer?
I have an electronic version from Mr. West, yes. I also have the electronic version of the state's proposal.
Okay, so if I took a half-hour recess, would that be a sufficient amount of time for you, Mr. West, to review the proposed instructions and give a copy to Mr. Zimmerman, and to also talk to Mr. Manti, and then we can proceed with this conference?
Yes, I think that would be great. I have a hard copy I can give Mr. Manti to work with, and the court as well at the time we're ready to get down to business.
Okay, thank you. I'll take these back if you'll give me your copy so I can compare them and be ready with you.
I'll give this to the court, of course, with the caveat that it is not a absolute final set of what we're proposing. It includes our instruction as well as one proposed by the state for comparison purposes. And, but otherwise, it's substantially, I think, where we're headed.
Right, thank you. I'll take that, and we'll be in recess for 30 minutes. Thank you. Please be seated. We're back on the record. Case number 12, CF1083A, State versus George Zimmerman. Mr. West, have you had an opportunity to discuss with Mr. Zimmerman the proposed instructions that you gave the court this morning?
For the most part, yes. We're working diligently to get through all of them. There is one issue that I want to raise before we're finished that wasn't included in the package that was provided to the court related to the lesser offense of manslaughter, but we can deal with that, I suppose, when we get to that particular instruction.
Okay. Mr. Zimmerman, you have a copy of the instructions with you, sir?
I'm not sure, I'm sorry, Your Honor.
Okay, can we make sure he has a copy? Have we done any work to merge the two versions together?
Yes, Your Honor.
All right, do you have now a third version for me, or?
I have two versions with markings on both, but I do.
Okay, you've done it on your copy.
Correct. The first issue is, I think,
Well, whose version, you could be seated, Mr. Zimmerman, whose version are we operating off of? I've been making my notes too, trying to find the differences in them, so.
I actually, how I found easiest to do it out here and most efficient was I just put them both side by side because
Okay.
much of it is virtually identical language. That's how Mr. West and I went through them. I've identified where the differences in his are from mine and mine from his.
Sounds
For-
like a good idea to me.
The first issue is actually a little more global issue. Mr. West has requested that everywhere within the instructions that the word defendant appears, that it be replaced with the words George Zimmerman. The state's position was that there are places where that has been done because the standard instructions indicate that in parentheses, defendant, and then you should put his name. There are places where the standard instructions literally say just the defendant, for example, and that is the reason that the state left that as is, just like with every other case in the state of Florida. So that is the first issue. I don't know that the court considers it particularly meaningful to the jury, but that is the first one.
Is there objection by the state?
There is, only because it appears to be a case of some kind of special focus or treatment. So on that basis, because we believe that this case should be no different than any other that is instructed in this court and everywhere else in the state of Florida, that would be it.
Well, I have noted that sometimes when you use the names are all in caps, and then sometimes they're in the smaller letters. I like uniformity is what I'm trying to get out.
Yes, Your Honor. How would you like it
And
to
I don't
appear?
think that it is objectionable to have George Zimmerman's name wherever it says defendant. But if we're going to do them all in caps, it's going to be all in caps for both names. If we're going to do it, you know, in small letters, then it's going to be that way for throughout. So is that acceptable to the defense?
Your Honor, our submission to the court has it exactly that way.
No, there was a couple times you put them in caps, so I just want it the way.
That was inadvertent. It was.
Well, I'm just saying I noticed it, and so what I would like them to do is that we all make a decision if they're going to be in caps or all in caps. And wherever it says defendant, it will have George Zimmerman's name.
Yes, Your Honor. And would the defense prefer that they be not capitalized, not all caps?
The proposal is that the first letter of the first name and the surname be capitalized, as is typically done for
Okay.
both Mr. Zimmerman and Mr. Martin.
We'll
Done.
make that change, and that will be throughout.
Done, Your Honor. As far as agreement goes, we were in agreement as to the page that begins members of the jury. I thank you for your attention. We were in,
Let's just go from the very beginning, the front page.
yes, Your Honor.
On the defense version of the front page, it just has the style of the case. The second page of the defense proposed has what the state has placed on the first page. Is there any objection to that all being on the first page as the state proposed?
That was a word processing issue, Judge. I took the set of instructions that the state sent to us and worked with that. So other than formatting, we started with the same set of instructions.
Okay, so the first page will be as the state has proposed.
Yes, Your Honor.
And then there was no changes to the members of the jury.
Correct.
We'll make the name changes to reflect this in the statement of charge. All right, that brings us to introduction to homicide.
There was agreement in that until we get to, I believe it's the very last paragraph.
Well, I know that the state yesterday had said that they were seeking manslaughter and aggravated assault, and now they're seeking felony third-degree murder and manslaughter as the lessers. Is that correct?
We are, and Mr. West has informed me that the defense will be seeking 0 lessers at all.
Okay.
So that would be the principal difference.
Is that what the defense intends to argue to the jury? Basically, the second-degree murder or not guilty are the only choices?
Yes.
Okay, I need to make sure Mr. Zimmerman is okay with that. Mr. Zimmerman, please stand up. You understand that the indication from counsel is, well, first let me start off that the Supreme Court, in doing their jury instructions, provides for what they consider Category 1 instruction as a lesser included offense and Category 2 instruction. So they advise us that there are certain crimes that can be a lesser included offense of the crime charged. Category 1 is a manslaughter charge. Category 2 includes a third-degree felony murder charge. And the state is seeking that. Are you aware that your attorneys do not want any lesser included charges being brought before the jury?
Yes, Your Honor.
And you've had discussion with your lawyers about that?
Yes, Your Honor.
And you also understand it's been indicated today that the, your attorneys are gonna argue in their closing argument to the jury that it's manslaughter or not guilty, those are the only choices?
Second-degree murder.
I'm sorry, second degree, I misspoke. Second degree murder or not guilty, that they wanted those as the only choices?
Yes, Your Honor.
And you are in agreement with that?
Yes, Your Honor.
Has anybody promised you anything to get you to make that decision?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
And you're doing it freely and voluntarily?
Yes, Your Honor.
Okay, thank you very much. Please be seated. So I'm sorry I interrupted you. The difference in knowing that the state changed it to third-degree felony murder instead of aggravated assault, where's the next difference?
The next difference is, actually, I believe on the next page, it's the very last instruction. I think the defense proposal is in just a moment I will instruct you, and I believe the state's version says I will now instruct you, or perhaps just I now instruct you. Again, that's one of those differences that I don't think really matters here, but how would the court prefer that to read? The state has it as of now, I now instruct you on these circumstances.
Defense have,
No preference.
okay, whatever the instruction says, so we'll go with the state's version that would include guilty of second-degree murder or any lesser crime.
Thank you, Your Honor.
It's my understanding that we've now addressed and resolved the issue that there are no lesser crimes, so it would simply end before Mr. Zimmerman may be found guilty of second-degree murder.
Okay, well, the state has asked for manslaughter and third-degree felony murder, and I'll hear argument about that.
I see.
Do you want to do the argument now? I don't know.
I can do it now, or I can wait till we get to that point in the
Okay,
instructions.
we'll get to the point on the instruction.
The second-degree murder, I believe it was the same, again, with the exception of the name name change issue. The
Is
possession
that
of,
correct, Mr. West? There are no changes being suggested to the charge of, as it's written for second-degree murder?
That's correct.
Okay.
same as to the possession of a firearm and discharge causing death page.
There is no objections to that or additions being requested?
You know, if I understand the requested instruction, that's because of the mandatory minimum, or actually because of the enhancement as a result of the use of the firearm.
That's my understanding.
Yes.
And I think that's the standard instruction on that issue.
So there's no objections to how that's written? Thank you.
Now we are at the point where there is the issue about lesser included crimes or attempts, Your Honor. And I guess I'll go ahead and whenever the court's ready, submit that argument.
I'm ready.
Thank you, Your Honor. The court characterized correctly that manslaughter is a Category 1 lesser included offense. I have tendered to the court several cases, and I've given counsel copies. The one I think that relates directly to, and now I'm just going to focus on the manslaughter charge, is State v. Montgomery. State v. Montgomery is a little more infamous opinion from the Florida Supreme Court from 2010, which originally declared that the then standard instruction for manslaughter was invalid. However, it is on page 5 of that opinion that I think the most operative language begins, actually begins at the bottom of page 4 under the heading lesser included offenses, continues on page 5. But it makes very clear that manslaughter is a Category 1 lesser included offense of first-degree murder. And what that means is delineated on page 5. A necessarily lesser included offense is, as the name implies, a lesser offense that is always included in the major offense. The trial judge has no discretion in whether to instruct the jury on a necessarily lesser included offense. Once the judge determines that the offense is a necessarily lesser included offense, the instruction must be given. Consequently, at Montgomery's trial for, in that case, first-degree murder, but also here as to second-degree murder, the trial court was required to instruct the jury on the lesser included offense of manslaughter. And continuing in the next column, the lesser included offense of manslaughter is just one step removed from second-degree murder. So the state's position is it's a Category 1 and mandatory for a reason. The Florida Supreme Court has said so, effective very recently, and it continues to be so, and the state believes that not only would it be error not to give it, but the state is requesting it as well. So as to that charge, at least, I believe that the issue is very clear.
Okay. Mr. West, you want to respond?
Well, we already did, to the extent that this is a decision that Mr. Zimmerman has made knowingly and without any coercion or threat, and his position is the state has charged him with second-degree murder. They should be required to prove it if they can. And if they can't prove it, then that is the failing of the prosecution. Had they wanted to charge him with manslaughter instead because they think that's a better chance under their theory of prosecution, whatever it may actually be, since we haven't heard it yet, they could do that. But we object. We want this to go to the jury on second-degree murder only.
Okay, thank you. Based upon State versus Montgomery 35 Law Weekly, Supreme Court 204, also cited at 39 Southern 3rd 252. From 2010, the court will give the instruction on manslaughter as a Category 1.
Thank you, Your Honor. The instruction as to manslaughter, I don't know that there is any quarrel with how that is worded, because the position, I think, of the defense was that it shouldn't be given at all. So we could discuss that at this point if there are any objections to that.
Given the court's ruling, are there any objections to the instruction provided by the state other than the changing of the names to be in conformity?
The reason for my hesitation is I'm still trying to sort out the evolution of the instruction on manslaughter by act. Of course, the court's aware there are several ways that the state could claim manslaughter occurred. One of them is by culpable negligence. There's no suggestion
There's nothing in the
of that.
information that
So
proves
it's
that.
only by act. And what gave me pause that I wanted to do some additional research on is there's a case from the 5th District Court of Appeal, Sherouse, S-H-E-R-O-U-S-E, that held that an essential element of the crime of voluntary manslaughter, which is what manslaughter by act is an intent to kill. So I've been trying to sort through that. I think maybe, since Sherouse, maybe the Supreme Court has addressed the jury instruction, and that maybe that's addressed in Montgomery. So I think maybe now that law has been, the holding in Sherouse by the 5th District has been now, I think, addressed, although not directly. I don't find a reference to that case in any of the subsequent case law, but I do see that Montgomery from 2010, a Florida Supreme Court case, does specifically say that the intent for manslaughter by act is the intent to commit an act that was not justified or excusable, which caused the death of, in this instance, Trayvon Martin. So I want to be sure that we've got that precise language, and if that's what the instruction says, then I suppose that we're past the holding in Sherouse, even though by jeopardizing it's still considered controlling precedent in this district, unless the Supreme Court has said otherwise. So that was my hesitation. I'm still trying to dig through that.
Okay, do you want us to come back to that one? Other than that, does the state's version of the instruction comport with the Supreme Court's required for manslaughter by act?
It seems to, yes.
Okay, so the only issue we have is your determination that the Sherouse case is covered by this instruction.
Yes.
Okay, well, we'll come back to that issue.
Thank you, Judge.
The other lesser included requested by the state, and I should point out, I included the next case, Martin versus State, which is the 1977 decision of the Florida Supreme Court, simply as the reason, and I think I disclosed this to counsel this morning, the reason for the abandonment of the request as to aggravated assault. I think the case makes it very clear that where the victim actually dies, the aggravated assault lesser may not be actually given.
I don't think that the evidence or the charging information support an ag assault.
And therefore, I have abandoned that in its entirety, but I want to put the case on the record. The next requested lesser is the third-degree felony murder. As indicated in the state's proposal, and I believe in comportment with the standard jury instructions, felony murder third degree, the state has to prove 3 elements. 1, that the victim in this case is dead. 2, it occurred as a consequence of and while the defendant was engaged in the commission of what's called a non-enumerated felony. And then 3, that the defendant was actually the person who killed the victim. The non-enumerated felony in this case alleged is child abuse. Obviously, the information alleges that the defendant shot and killed the victim, that the victim was under the age of 18. And child abuse must be, according to the third-degree felony murder instruction, defined. I have defined the elements of child abuse in the felony murder instruction. And I've also included what I believe is required under the child abuse instruction, which is when the child abuse is premised upon physical injury, that there is a required reference to Chapter 39 to define what that physical injury might mean under the Florida statutes. So that definition has been likewise included. The case law upon which I would rely begins, I think, in the stack that's been provided, with Hermanson. That's Hermanson versus State, which is 604 Southern 2nd 775, which is a Supreme Court of Florida case from 1992. And in that case, as set forth on page 2 of the court's decision, the third-degree murder provision of Section 782.04 of the Florida statutes provides that the killing of a human being while engaged in the commission of child abuse constitutes murder in the third degree and is a felony of the second degree. In that case, unfortunately, the state combined the instructions for both child abuse and child neglect, but otherwise, that was the reason, I believe, that the conviction was reversed. But obviously, the reason the case is there is to show that, yes, third-degree murder premised upon an underlying conviction for child abuse is actually a rational or a listed offense in the state of Florida. The next case to do with that situation is the Klein's case. That's C-L-I-N-E-S, 765 Southern 2nd, 947 from the 5th District Court of Appeal in 2000. In that case, the child abuse was committed by waving a gun around and the gun going off and the child being injured. In this case, the court said, and I'm reading from the second column, it's a one-page opinion, the statutory offense of child abuse is no longer limited to actual physical or mental injury inflicted on a child. It now includes any intentional act that could reasonably be expected to result in physical or mental injury to a child. Further down, the court indicates that what they found in that case, and they described it as irrational, hostile, and reckless behavior by an excited or agitated person, unfortunately often results in shootings which perhaps were not intended. All it would have taken was slight finger pressure to cause the gun to fire had Klein stumbled or lost his balance, or if the mother, instead of grabbing the child, had tried to disarm him. A bullet released and ricocheting about the nursery was a definite possibility in this scenario. In our view, these undisputed facts and inferences arising therefrom were sufficient for the trial judge to have concluded Klein's intentional acts placed the child in a zone of reasonably expected physical danger. I couple that with the other case in the state's packet of Garrett versus State, which is 978 Southern 2nd 214. That is a 5th District case from 2008, where we talk about the trial judge supplementing the standard jury instruction, which does not provide the definition of physical injury for child abuse. In that case, and if the court looks at Chapter 39, there is something like 60 different possible types that might need to be included depending on the allegations. In that case, the court included the definition to include asphyxiation, suffocation, or drowning. But the court goes on to say that it is the responsibility of the court to correctly and intelligently instruct the jury on the essential and material elements of the crime. So that is the reason for the definition of physical injury being provided. It is taken from Chapter 39, which, as the child abuse instruction requires, is mandatory to define the type of physical injury pursuant to Chapter 39. The next case is Sheridan, S-H-E-R-I-D-A-N, which is 799 Southern 2nd 223, 2nd District Court from 2001. Here again, we have third-degree murder premised upon being a lesser included offense. In that case, it was a first-degree murder charge, but it was third-degree murder, and the underlying offense committed by Sheridan was a non-enumerated felony. In that case, at the time, it was aggravated battery. Aggravated battery, of course, is now an enumerated felony. On that basis, the defense counsel in that case argued the third-degree murder instruction should have been given and was proper. The trial judge was inclined to give it, but ultimately did not. And the court goes on to say in head notes 2, 3, and 4 that the trial judge's first inclination was correct. If, in that case, the non-enumerated felony results in death, it can indeed be third-degree murder. Further, if there is evidence supporting the lesser charge of third-degree murder, the defendant is entitled to such an instruction to the jury. And on to the next page, after citation to another case, we find the failure to give the third-degree murder instruction in the present case to have been reversible error. The next case is Jakubowski. It's Jakubowski, which is the Second District Court of Appeal decision from 1986. And again, here we have a third-degree felony murder. In that case, the victim was 6 years old, based on an underlying felony of child abuse. And in that case, the defendant was charged both with second-degree murder and third-degree murder. After deliberation, actually the court apparently entered JOA as to the second-degree murder, and then after deliberation, the jury convicted of third-degree murder based on the underlying felony of child abuse. And then the next is Spagnuolo versus State, a much more recent decision, which is from June 28th of this year from the 5th District Court of Appeal, and that's Spagnolo. And once again, this is a case where the victim in this case was a child. The child was killed in a homicide fashion, and in this case, the verdict form included a finding or a possible finding for murder in the third degree. And in this case, of course, the problem was that the court conflated, and the state apparently proposed and asked for a conflation of the abuse and neglect language. The state is not requesting that here. We're requesting abuse only. But the court went on to say, and I'm reading from page 3 of the opinion, as used in 827.03 Florida statutes, which is the child abuse, the definition of child abuse is 1, intentional infliction of physical or mental injury upon a child, 2, an intentional act that could reasonably expected to result in physical or mental injury to a child, or active encouragement of another person. Obviously, there's no factual support for that third one, so it has been omitted in this case. Over in the right-hand column, we continue, and under headnotes 3, 4, and 5, the court quotes another case, which I will get to in a moment, but quoting State versus Sigler, S-I-G-L-E-R, they indicate that a conviction for third-degree murder requires an underlying felony and a jury determination of the existence of such felony. That is why the state has proposed, and we think it's required, to define the elements of child abuse and also to indicate that the state's burden is to prove that underlying felony beyond a reasonable doubt, which is exactly the way the instruction reads. The next case is Alfieri, that's A-L-F-I-E-R-I, which is a 4th District Court of Appeal case from 1998. And that stands for, again, simply the proposition under head note 3. And here again, we're talking about third-degree felony murder. But in any felony murder prosecution, the state must prove the underlying felony beyond a reasonable doubt. Don't have to necessarily charge it, although I would submit that the information contains the requisite requirements, but we do have to establish it. So that is the reason the instruction language is given. Finally, Faison, F-A-Y-S-O-N versus State, which is 684 Southern 2nd 270. It's a 1996 decision from the 1st District Court of Appeal. And I'm reading from page 2 of that copy, headnote 2. The facts in that case, they describe the similarity to another case called Gonzalez, G-O-N-Z-A-L-E-Z. Argued that the convictions of the lesser included offense of third-degree felony murder and attempted felony murder were inconsistent. The court went on to say that no, and I'm reading from the second column at the bottom of the last full paragraph, jury's verdict in the instant case of guilty on the lesser offense doesn't mean that the aggravated battery conviction, in that case the top count, had to be reversed. So the reason that I put this in here, Judge, is to show that I anticipate an argument that the defense would argue this is a legally inconsistent possibility, and I put that in there to say that no, there's nothing legally inconsistent about it, and even if there were, the correct way to phrase it might be a logical inconsistency, and that is perfectly permissible and should be charged that way. That's the reason for the Faison case. So the state's position is as follows, that when one commits a non-enumerated felony of child abuse and the child dies, the child being defined as a person under the age of 18, that constitutes and can constitute, as the cases have illustrated, felony murder in the third degree. I have also provided the court with the case of Sigler versus State, that's SIGLER, 881 Southern 2nd 14, which is a 4th District Court of Appeal decision from 2004. And again, in that case, and I'm reading from page 2 in the right-hand column in the middle paragraph under headnote 2, third-degree felony murder requires an underlying felony in this, and in that case it was not child abuse, but it was harboring a prisoner. Second-degree murder, in distinction, requires the killing be done with a depraved mind. Second-degree murder does not require an underlying felony. The court goes on to say on page 3, in the second column at the top of the first full paragraph, that the defendant in that case, but I would submit the state equally, is entitled to have the question of guilt for third-degree felony murder submitted to and determined by the jury, so long as the facts are appropriate. Thinking that there might be some question as to whether or not the age of the victim is required to be known by the defense or the defendant, I provided the case of Witt, W-I-T-T versus State, which is a 5th District Court of Appeal case from 2001. And they're pretty blunt and clear that because this is a crime against a child, the ignorance of the age of the victim is not a defense. It would be strange indeed to say the state has a compelling interest in protecting underage persons from sexual exploitation, but not in protecting them from the infliction of death or permanent disability or disfigurement. Contrary view can only be characterized as quaintly Victorian. And so, Your Honor, the state believes that the law and the facts demonstrated herein would permit the instruction on third-degree felony murder so long as it is compliant with the requirements that A, the underlying felony be alleged, B, that the jury is instructed on its elements, C, that the jury is told that it needs to be found beyond a reasonable doubt, and 4, that there is also a definition of the type of physical injury being alleged. And in this case, the state has alleged it means death, permanent or temporary disfigurement or impairment of any bodily part, which is the statutory definition under Chapter 39. That is the basis for the state's request in this case. In other words, second-degree murder requires, as indicated in the case law, that depraved mind. Third-degree felony murder does not require that. It simply requires that the victim be under the age of 18 and be subjected to what constitutes child abuse. Now, self-defense, justifiable use of deadly force, obviously would apply to that charge as equally as to any other. There's no dispute about that. But that is the reason for the basis for the state's requested instruction.
Okay, thank you. Mr. West?
Oh my God. Just when I thought this case couldn't get any more bizarre, the state is seeking third-degree murder based on child abuse? Is the court going to give this any serious contention or consideration? Because if so, we have a lot of talking to do. We can start with Mr. Manti dumped all of this on us sometime around 7:30 this morning. There was an email, oh, by the way, we've changed our lesser included request from aggravated assault to third-degree murder based on child abuse, and put 10 or 15 cases that obviously he has spent hours, if not days, if not in fact maybe more than a year plotting for this moment when he can spring it on us and the court. Somewhere we wondered why the state would put this vague allegation in the information that Trayvon Martin was 17. No other charge of child abuse, no evidence of anything other than this statement that Trayvon Martin was a minor, 17 years old. First of all, I moved to strike it as surplusage because it's not related to any element of the offense for which George Zimmerman is charged, nor related to any conceivable lesser included offense. So I guess what's happened now, since the time that the state filed its information in April, that they've been lying in wait, collecting all this loosely connected child abuse case law where 2-year-olds have been shot by someone who was reckless with a gun, or some child exposed to horrible deprivation or abuse resulting in death. Just so at this moment, on the day of closing arguments, we would have to deal with it. Well, I can say it's certainly consistent with the way this case has proceeded since April, but it's certainly just as disingenuous as well. This is outrageous. It's outrageous that the state would seek to do this at this time in this case. Now, if the court wants to recess for several hours so we can research and review these cases, draft a memo of law, we can do that. And we certainly are entitled to the opportunity to respond in a meaningful way. But it's just hard for me to imagine that the court could take this seriously. Certainly the court wasn't provided with the case law either, nor given any hint that this is where this was going to go.
Well, in all due respect to that statement, the court hasn't been provided a lot of things that have been requested to have hearings that the court has had up until late in the evening, until the last minute, or I requested of it. So that in and of itself is not an argument, and I don't want to go there. So let's go on to the argument about this instruction.
I'm not prepared to make an argument. This was just emailed to me, buried in the set of instructions that the state's obviously been working on for months and months and months, just to spring it on everyone at the last minute. Mr. Manti has this fully formed, organized argument based upon all this case law that I guarantee you he didn't come up with between yesterday when they wanted aggravated assault and this morning when they now want third-degree murder based on child abuse. Really? Ms. Corey's sitting right there apparently approving of this.
That's not proper argument.
It's not
in this
fair
case.
to me, it's not fair to Mr. Zimmerman or Mr. O'Mara or the court for this to happen like this right now. I need time to sort this out if the court is going to give any consideration to this remarkable, remarkable suggestion by the state that somehow third-degree murder based upon an 827, Chapter 827 and Chapter 39 violation of the child abuse statutes could somehow, when Trayvon Martin is shot straddling George Zimmerman, pummeling him, that somehow George Zimmerman was engaged in child abuse?
In the Supreme Court's jury instructions that are online and in the rules of criminal procedure books indicates that the offense charge of second-degree murder, a Category 1, is manslaughter. A Category 2 is third-degree felony murder, vehicular homicide. Non-homicide lessers would be an attempt, culpable negligence, aggravated battery, aggravated assault, battery, and assault. These are part of the jury instructions that have been known to this court since I've been on the bench.
Your Honor,
So
did the court ever for a
pos-
second think we were
I'm
going
not
to be-
finished speaking,
I'm sorry, I
please.
apologize.
Thank you. The possibility of a Category 2 is known to counsel at the beginning of the trial.
Your Honor, in the same way we would expect vehicular homicide be offered?
But the
It's-
evidence doesn't support that, and the state's argument is, at first yesterday, when they provided the court with the possible lessers, and one of them was aggravated assault, I didn't have any information available to me that led me to believe that that would be a charge that would be given, because the facts did not support an aggravated assault lesser included offense.
Yes.
Their argument today is that the facts support a third-degree felony murder with the underlying enumerated felony being child abuse. That is permissible under the statute. If you need I'm not gonna give you hours. You have, I don't know how many lawyers you have working with you on this case. Well, you have 4 in the courtroom, and I know there's a room downstairs full of people who.
Ms. Truitt's a
bring
lawyer,
it up.
and Mr. O'Mara's a lawyer. That's who we have as lawyers on this case. Everyone else is a volunteer, an intern, who has really done remarkable work, but we can't rely on non-lawyers to do the kind of work that's necessary right now. Judge, this was a trick. Doesn't the court realize this was a trick by the state?
My intention right now is to get through the rest of the jury instructions, because if we have any arguments about the others, I would like to get them resolved. We will come back to this one. I understand your argument. We will come back to this one.
The state also proposed, I think it is required that the court instruct as to the justifiable and excusable homicide, just as we do with second-degree murder with respect to the third-degree murder and the manslaughter, so that has also been included. The next, I guess, area of discussion moves to the justifiable use of deadly force instruction.
Okay, I'm there. I have both in front of me.
At the court's request, I did attempt to incorporate much of the proposed language from the current proposal being considered by the Supreme Court's jury
Just one
instructions.
second, Mr. West, are you caught up to the justifiable use of deadly force?
No, I'm not caught up
Okay,
yet.
well, let me know when you've got it in front of you.
So we're skipping over the proposed lesser included of third-degree murder
Yes.
based on child abuse.
Yes, we are. We're now on to the justifiable use of deadly force instruction.
I object. I object to the instruction that the state proposes, and I have prepared an alternate instruction that I think the court probably has.
Well, there are some differences, and I know that there are additions in the defense. The state was just informing me that they have incorporated some of your suggestions, and that's where we are on that instruction at this time.
Okay?
As it relates to that instruction, Your Honor, the first line really isn't in dispute, with the exception of the name change. That being, at issue in this case is whether George Zimmerman acted in self-defense. The next difference is in the next sentence. It is a defense to, Mr. West has said.
I'd like to argue my own instruction rather than having Mr. Van
I
Tye.
see what the differences are.
Sure.
It's a difference in what the lesser included offenses are.
Correct. And I don't have any objection to the phraseology in the defense's proposed instruction, such that it would read, it is a defense to the crime of second-degree murder and to the lesser included offense, whether we make that offense or offenses of manslaughter or manslaughter and third-degree murder. I guess that's to be determined, but the way it is phrased is not objectionable to the state. Deadly force, that line appears to be the same. The next marked difference is that the state's proposal is to include the 2 paragraphs suggested for Section 782.02, being the use of deadly force is justifiable, and it used to read only, but the current proposal omits the word only, and so this state proposal also omits the word only from the standard instruction. So it reads, use of deadly force is justifiable if the defendant reasonably believed that the force was necessary. That entire paragraph, as well as the next paragraph, which defines aggravated battery, which is, as I understand it, the enumerated violent felony or the forcible felony that the defense is alleging was being perpetrated upon the defendant.
Is that correct?
I'm not clear what Mr. Van Tye's referring to now.
If you were to look at the state's suggested instruction, the 3rd paragraph down, so we're talking about the 3rd and 4th paragraph, it requires for the justifiable use of deadly force, for the defendant to prevent imminent bodily death or imminent death or great bodily harm to himself while in attempt to commit some type of enumerated defense upon him.
We're not asking for that instruction. We don't think that it's the issue in our case. I've drafted an instruction that I think specifically addresses the legal issue before the jury and properly sets out the standard that the jury should apply.
Okay.
in the
So
court.
let me just make sure I have this correct, that the defense is not wanting an enumerated felony
That's right.
upon him by the victim in order to have justifiable use of force.
That's right.
Okay. If that's what they want, that's what I'm gonna do.
Well, if I could be heard on that.
Yes, you may?
The standard instruction, both the current and the proposed, indicate that that is actually a required instruction because it is essentially if you look at the statutory citation 782.02, that is the definition of justifiable use of deadly force in the Florida statutes. The next paragraph simply defines the forcible felony. So in order to be entitled,
Okay, what section are you saying? I've got the 3.6F, justifiable use of deadly force, the one that's being considered by the Florida Supreme Court.
correct, there is if you look at the italicized, give if applicable 782.02 Florida statutes, the use of deadly force is justifiable. It is that section, and when you
But it says give if applicable.
correct, and 782.02 is entitled, and this is the statute under homicide, it is justifiable use of deadly force. That is what section 782.02 is, and my argument is this is a homicide case, and therefore that is mandatory. That is the reason it's referenced in the standard instruction. It's a homicide, and therefore, if they're seeking a request on justifiable use of deadly
Okay,
force,
if you look at the italicized part on page 2,
yes,
it says, define applicable felony that defendant alleges victim attempted to commit.
yes.
And they're saying they're not alleging any.
If they're not alleging that, then my position would be they're not entitled to a justifiable use of deadly force instruction. Because unless the victim was doing that, we don't have this situation. So if they don't want to allege that Trayvon Martin was committing any forcible felony upon the defendant, then my argument would be what they're telling the court is they don't believe this is justifiable use of deadly force. I didn't take it for a second that that's their argument. That's the reason I put this language in here.
Response?
Yes, the state is seeking this instruction as part of a larger scheme, another trick that the state is seeking.
And I don't want to
Because,
hear the word trick anymore in
All right.
regards to these arguments, please.
well, we don't want that instruction. We're not claiming aggravated battery specifically, that so as the jury would be instructed on the elements of aggravated battery. The state wants the court to come up with a definition of aggravated battery, and it can't get that until it convinces the court to include that Mr. Zimmerman is claiming that Trayvon Martin was committing an aggravated battery. This instruction that I provided is exactly the law, and it's the instruction that's in the standard that relates to Chapter 776. That's the justifiable use of force chapter, and that's the language that we used in our instruction because that's the issue. In fact, Judge, it's the only issue in the case. It's always been the only issue in the case, and that is that a person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. That's the only issue.
And then that section goes on to say, while resisting an attempt to commit, parentheses, applicable felony upon him or in any dwelling in which he was present.
Well, he wasn't in his
So
house.
it's either the applicable felony or in his house. That's the
No.
that's a justifiable use of deadly force.
No, we disagree.
Well, then give me case law that says that that's a wrong interpretation.
Look under the standard instructions. The standard instructions, actually, I have both. I have the proposed ones as well that the court directed us to. The court is looking at the wrong part of the instruction, as is Mr. Mantine. Give, if applicable, under 776.012 and 776.031. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. That's one. Or the imminent commission of felony battery, or, I'm sorry, the applicable or forcible felony. In this instance, the state claims aggravated battery, or the imminent commission of aggravated battery against himself. It's an alternative. It's not required, and we're not asking for it. We're asking for exactly what happened in this case, and that is that George Zimmerman was resisting reasonably imminent death or great bodily harm, as this proposed instruction reads, and in fact, frankly, as the old one did too.
These proposed instructions are rather lengthy, and they give a lot of alternatives. The very first one says to read in all cases. Then thereafter, it says give A or B as applicable.
Yes.
Also, there's some instructions to give only if there's evidence of what is seeking to be defined.
The basis for the 776.012 instruction is chapter 776.012, which the court just read, and the court read it correctly, that it requires, one, justified in the use of deadly force doesn't have a duty to retreat if, one,
That's not
reasonably.
776.012.
It is.
I'm looking at the instruction.
But what I'm saying is the instruction refers you to the statute, and I'm reading the statute.
Okay.
The statute says, a person is justified in using force to accept deadly force against another when, to the extent the person reasonably believes such conduct is necessary to defend himself or herself. However, a person is justified in the use of deadly force and does not have a duty to retreat if, one, reasonably believes it's necessary to prevent imminent death or great bodily harm to himself or herself, or to prevent the commission of a forcible felony, or under another set of circumstances.
Okay, they're
That's-
all or.
I'm sorry?
They're or. They're
Yes.
alternative.
Yes. And that is the 012 instruction. The justifiable homicide instruction is what I have written here, which is the 782.02, which I have yet to hear why that is not applicable. Justifiable use of force is required to be given. It is certainly applicable. I don't dispute necessarily that Mr. West's 776.012 might also be applicable. In fact, I include it later. But what he's asserting is it's the only thing that's applicable, and that is where he and I part company.
Okay, that's an issue. What about the rest of the instruction?
The rest of the instruction, beginning with the line, however, the use of deadly force is not justifiable if you find the defense has inserted the phrase beyond a reasonable
Okay,
doubt.
you're going too fast for
I'm
me.
sorry. It's the
What
line that begins,
page?
however,
Okay,
the use of deadly force is not justifiable if you find the defense has inserted the phrase beyond a reasonable doubt at that point.
okay, I see that. What is the
And-
purpose of that?
I assume it is simply to restate what is said at the very last paragraph on the next page. Convinced beyond a reasonable doubt, it is simply a second place to say it, and if they want it there, we'll put it there too. That's
Okay,
fine.
so that's not an argument? What is the next?
There's a larger issue here, though.
Well, they're not arguing with it being in there, so we don't need to go there.
Well, I included this language as a mirror of the change.
They're not objecting.
But I am, in the
Oh,
sense.
you don't want it included in what you put in yours?
No, I'm talking, I put beyond a reasonable doubt in there, and the state agrees, so we're past that.
Okay,
I included this whole section, which is based upon Mr. Zimmerman initially provoking the use of force against him.
I don't think they have an objection to the section.
No, I do, but I
Well, then why'd you
included
put
it
it in your instruction?
for discussion,
Okay,
because because it only becomes relevant if indeed there is substantial evidence to establish that Mr. Zimmerman provoked the use of force against him as defined by law. And I think the state should be required to articulate the facts in this case upon which it would claim and argue that Mr. Zimmerman provoked the use of force against him. And if they can't do that, they shouldn't be able to argue it, and the jury doesn't need to deal with it. So this, in some ways, can be a misleading instruction, not applicable to the facts, unless the state can articulate to the court's satisfaction that there's some construction of these facts that could establish beyond a reasonable doubt by this jury that George Zimmerman provoked the use of force against himself under the prevailing case law that defines what provoked legally means.
okay, that's fine.
Certainly. Obviously, we are talking about both facts and reasonable inferences therefrom. The facts that would support and the inferences therefrom that would support whether or not the defendant provoked this is that, number one, the defendant followed the victim. He admitted that, actually. Number two, obviously the testimony of some of the witnesses, number one, Ms. Bahadur, who hears a pursuit. Number two, Ms. Gentle, who hears the defendant involved in an interaction with a person who he tells to get off, tells Ms. Gentle he is following me, he is doing this, he's coming up again. She hears a scuffle, a struggle, some physical conduct. There are, I believe Ms. Serdyka saw the defendant on top of the victim. And she said before the gunshot, I understand that's a point of contention and a point of dispute, but it is still a fact in front of this jury and they can draw reasonable inferences from it. So when you combine the known facts that this defendant is the one, at least under a certain construction of the facts and inferences therefrom, who initiated the confrontation, that is provocation. It is not just mere words, as I think is going to be the argument, but it is apparent that there is a physical accosting. There is a close to close quarters. The defense's version, obviously, I think we've gotten pretty clear, is that no, the defendant isn't the one who initiated this or provoked it. It is rather the victim who provoked it. I think the facts testified to leave both inferences equally valid. There are facts to support both, and that is the reason that I think the instruction should be given to the jury. They're free to argue that no, what the defendant did does not constitute provocation, or that the victim did all the provocation. But I think the facts, as testified to by the eye and ear witnesses, as well as the defendant's own statements, and let me add to the fact that when you add on top of that the defendant's own statements, some of them have been shown to be materially A, inconsistent with one another, and B, false, that those are inferences that the jury could make that the defendant provoked this initial encounter. I'm sorry, I should add, we had that argument sort of at the JOA.
And the court didn't address that argument in the JOA, and I don't know if the court intends to draft an order specifying why the state, in the court's opinion, had met its burden. However, what Mr. Manti just said isn't the law, and not even close to the law. And it's not factually supported by the witnesses that he claims now he can use to support this notion of provocation. Celine Bahadur, if the court will recall, for the first time ever came up with this story in court that there was some sort of vague movement from left to right, which would suggest in some sort of vague way that people, not necessarily Trayvon Martin or George Zimmerman, but somehow people she thinks might have moved in a direction toward this, in the direction of the T, and we know where her house is on this, it's the third one down. Okay, that's as close as she ever got. And she said for the first time ever in court after she met with Mr. Del Rionda the night before. That was pretty clear in the record, that she had no clear evidence to offer at all, other than this sense that she sensed movement or shadows or something. So, let's assume we can't even assume that's true because it makes no sense compared with the other evidence in the case. That Jane Serdyka's evidence would support provoking. Jane Serdyka could not have seen what she claims to have seen. It's physically impossible, and that's been established by medical testimony, by ballistics testimony. She says that at the time the shot was fired, she was looking out the window, and immediately after the shot, she saw George Zimmerman stand up and Trayvon Martin lying face down. We know that just couldn't have happened, that she's wrong. Whatever she thinks she saw, she got it wrong. No matter how well intended she is, she got it wrong. Because Trayvon Martin undeniably was shot in the front, not in the back. That's not evidence worthy of any consideration by anybody on what happened at the time of the shot. She didn't see the confrontation initially. She didn't see George Zimmerman be struck in the nose by Trayvon Martin or anything else connected with that. She heard some voices, and she made gross, inaccurate assumptions based upon hearing those voices, but she saw nothing by her own testimony that would establish George Zimmerman provoked the contact between him and Trayvon Martin. And let's not forget, Judge, that when Trayvon Martin was known to have been running away from George Zimmerman was still in his car. Ms. Gentile corroborated that at the time the second to last call disconnected is when she told Trayvon Martin to run, and he did. Because the next time she talked with him, he told her that he had lost the man. The reconnect time was about 20 seconds. And then they stayed on the phone for the next 3 or 3.5 minutes. In the meantime, George Zimmerman is on the phone for a good bit of that time with the police. So, what we know from that in and of itself is that Trayvon Martin had 2 or 3 minutes to get home 348 feet. He had 2 or 3 or maybe 4 minutes to do that and chose not to. He decided either to go home and come back, or that he decided to hang around and wait for George Zimmerman to get off the phone so he could confront George Zimmerman and ask him whatever he said, why you follow me, or man, what's your problem, whatever that was, he said he's the one that initiated it. That's clear from Ms. Gentile and frankly any other evidence that's in this case. We know that happened from the physical evidence as well as the circumstantial evidence, which as we know is just as good as direct evidence according to Mr. Delarionda. So that's established clearly. There was no pursuit. You heard the call. Mr. Zimmerman said when he was told, we don't need you to do that, okay. And he was on the phone for another, minute or so? We know where the event took place. It started at the T. George Zimmerman's key with the flashlight was found right there, the one he had in his hand on his way back to the car, in the direction of the car, thinking that the police were going to arrive any minute. It is outrageous to suggest that there is sufficient evidence to offer to this jury that George Zimmerman provoked this incident. Because what the law requires in order to have provoked this incident is proof that there was the use of force, the actual use of force, or the threatened use of force. Walking up to somebody, following somebody, is not enough to get you to the legal definition of provoke. That's the Gibbs case. It's absolutely clear where the court committed reversible error by not saying that, if you will, in its instructions. Mr. Mantine knows that case. There's no legal issue, as that's what provoked means. And for him to say that George Zimmerman followed Trayvon Martin is a legally supportable basis to claim that he provoked the violence that Trayvon Martin used against him is disingenuous and legally incorrect. He knows that, and he knows better than that to try to convince the court. So I have the Gibbs law, case law. The court knows how that works, and the state has not offered a compelling argument supported with facts or the law why the court should introduce this issue to the jury and make them even consider that George Zimmerman may have provoked this.
Gibbs, of course, is a justifiable use of non-deadly force case, but the only language that the Gibbs court said should be included, rather than the full paragraph, is force or threat of force under the facts of that scenario, of that case. Before I get there, let me just point out that the entire thing I've just heard is we don't think that the witness was credible, or we don't think that the jury should draw a certain inference. But Mr. West hasn't said yet that those aren't facts that are before the jury and that the inference is not permissible. I understand he doesn't think they're the right ones, but that's not a reason not to give an instruction. The instruction is what are facts before the jury and what are at least some reasonable inferences to draw from them. When a person admits following another individual, when someone hears the individual who's being followed say, let go, get off, is running away from and in fear of this other person who is following, when there is a sound and evidence physically of a physical struggle between them, there is evidence that the defendant is the provoker, especially when he admits that he was following, pursuing both on wheel and on foot. So again, we sort of hashed that out at the JOA I had thought, but there is evidence and inferences from the evidence. I understand Mr. West doesn't think any of it's credible or right. Respectfully, that's up to the jury, not Mr. West. So the issue is, I think the provocation language should be included. The only issue that I hear is whether or not it also ought to, on top of the issue of provocation, include the phrase force or threat of force. And again, carrying a firearm or grabbing or accosting to the point that someone hears let go and a physical struggle, that is evidence of force or threat of force. It doesn't say, Gibbs certainly doesn't say deadly force, because of course Gibbs is itself a non-deadly force case in the first instance. So the state's argument is the defense is arguing what is credible, not what is actual.
I understand both arguments.
Well, let me point out, as a matter of law, following someone on foot or by car is not against the law. You are absolutely allowed to do that if you want to, and especially if you want to tell the police where the person is. That cannot be considered provocation under the law, just like because you happen to have a concealed weapons permit and have a licensed firearm on your person, that cannot be considered actual force or the threat of force. It obviously, under Gibbs and the reasonable construction of this issue with our common sense, is force means force. Force means force, physical force, or the threat of physical force, not a gun that's properly concealed, and certainly not the lawful act of doing what you're allowed to do in this state, which is if you see somebody suspicious, by your own definition, frankly, whatever you think is suspicious is good enough under neighborhood watch or by any other measure, and you call the police and you're asked to let you know if he does anything else, and you follow the person in order to be able to tell the police where they went, by car, on foot, what have you. That's not legal provocation, and it would be error and frankly promoting miscarriage of justice if the state were allowed to argue that to this jury.
There is a separate instruction regarding whether or not there's unlawful activity. We're not asking the court to instruct the jury that wearing a hoodie and walking in the rain is also lawful activity. There is a separate instruction altogether.
We're not there yet.
I understand. Here, we're talking about whether or not the totality of the circumstances.
We're still under the 776.041.
Yes.
And the defense doesn't want it, the state does. The court is not going to give it. next paragraph in the defense version starts with, however, before you can find George Zimmerman initially provoked. That's in the defense version, it's not in the state's version. You want to talk about that?
Well, my understanding is, from what I've heard before, that it's only there in the defense version.
Because of 776.
Because of 774.041, so if the court is giving none of that, I would assume they don't want that in there either.
Okay. Then we go to the next one in the defense is, you are further instructed that merely following Trayvon Martin by car or on foot in order to report his location to the police is not sufficient for you to find that George Zimmerman provoked the use of force against himself by Trayvon Martin. Before George Zimmerman can be found to have initially provoked use of force against himself, George Zimmerman must have used actual force or the threat of force against Trayvon Martin.
I think that's the same issue.
So all of that comes out too, is that correct?
Was all part of the extended.
Just making sure we get everything here.
Right, Judge.
The next one is the paragraph that says, in deciding whether George Zimmerman was justified. I don't see any differences in those paragraphs, am I correct?
Yes.
That's acceptable to both sides?
So is the next paragraph.
Well, on the next paragraph, interestingly enough, both of you did not follow tally and take out the comma. And cases have been reversed because of that infamous comma after the words including deadly force. That comma should be removed based upon tally versus state at 106, Southern 3rd, 1015. Do we agree?
I agree, Your Honor. I'll remove it. My
Okay, so that
apologies.
comma, do you agree, Mr. West?
That would read, stand his ground and meet force with force, omit the comma.
No, that comma stays in.
Oh,
The including deadly force, that comma comes out.
oh, sure, that's fine.
Do both sides agree with that?
Yes, Your Honor.
Do you agree that that complies with tally?
I do.
Okay, so there's no other issues in that paragraph. The next one in the defense version is, you are hereby instructed that following someone by car or on foot in order to report their whereabouts to the police is not unlawful activity under Florida law. What case law or statute or anything do you have that supports that requested instruction, Mr. West?
It is an accurate statement of the law.
Show me where that's codified.
Well, in this instance, it's sort of codified by absence, in the sense that there is no criminal statute that criminalizes the act of following someone on foot or by car.
Well, you're free to argue that, but I don't think that should be included in the law that the court gives to the jury.
That's our theory of defense. We're
And
asking.
you can argue it.
Well, I'm asking for an instruction as part of our theory of defense because, and I think this is critically important because of the facts of this case. Thinking back to jury selection, knowing what the court knows about the way this case has been presented in the media long before that, somehow, and last night I heard people talking about this critical issue of if George Zimmerman was following Trayvon Martin, then he's guilty of something. And that's just not true. If this jury were allowed to think for a second that following Trayvon Martin is illegal, they're going to think that he committed some sort of unlawful activity under the instruction above it that the court is going to say. We know already that Mr. Manti and Mr. Delariando want to suggest to this jury that somehow the act of following Trayvon Martin was illegal. It wasn't. It can't, and the jury absolutely has to know that, and they absolutely have to know it from this court. Otherwise, just arguing it doesn't make it so, and it would be misleading to the jury. It would confuse the jury on an issue for which there needs be no confusion whatsoever. The standard instruction says if Mr. Zimmerman was not engaged in an unlawful activity, and was attacked in any place where he had the right to be, he had no duty to retreat and had the right to stand his ground, et cetera, et cetera. For the state to be allowed to suggest that by following Trayvon Martin in the car or on foot, that in and of itself suggests unlawful activity is absolutely wrong. It's absolutely would be a misstatement of the law. It would be a factual distortion that would lead to an improper verdict. So it's our theory of defense. It's a proper statement of the law. And if you want us to tweak the language a little bit, that's different. But as our theory of defense, we want this jury told by this court it's not illegal to follow somebody, especially if you're doing it to tell the police where this person went.
Response?
As the state objects, we would note that it's the first time I've ever heard unnamed media commentary cited as legal authority to the court. I would submit that while following itself might not be illegal, that following is one factor that the jury is free to consider in this case. It is something that evinces the defendant's state of mind. It doesn't have to be illegal, and I don't think the instruction, if we want to talk about what confuses the jury, when the court starts telling them things like it is not illegal to walk across the street, it is not illegal to walk home from 7-Eleven in the rain wearing a hoodie, it is not illegal to be armed with a pack of Skittles, that tends to confuse the jury. It is also inappropriate for the court. Basically, this requested instruction is a demand for judicial notice of a fact in question in the case to be communicated and given the imprimatur of a jury instruction to the jury. The state contends that it is not legally proper to request it. We object to any format of this, tweaked or otherwise.
Ask the state to produce the Florida statute that makes it illegal to follow somebody. And then I'm
You're
good with
asking him to
that.
prove a negative, basically. And
No,
so my question to you is, show me a Florida statute that says that this is the law in the state of Florida. You're asking me to put in here is not unlawful activity under Florida law. You
Well-
can argue that to the jury in the closing argument.
Judge, Detective Sereno said so in his testimony. Any law enforcement
Well, as
officer.
far as I know, I don't think that he drafted any of the legislation.
Mr. Manti didn't say it was illegal to follow someone. He can't cite you. You know, criminal statutes are pretty precise. They're designed to put people on notice what's illegal and what isn't. So if it's illegal to follow somebody, to tell the police where they're going, there better be a law against it. Otherwise, you can't say it's illegal to do that.
Repeating your argument. I've heard the argument from both sides. I am not giving that instruction.
We submit that's an integral part of our theory of defense, and the
And-
court commits
and you
error
can-
by not instructing the law, this jury properly on the law. And
I
we-
understand. I've already ruled, and you continually disagree with this court every time I make a ruling. I have provided you on 3 separate occasions with the court's professional conduct in the courtroom, and included in that is, do not continue to argue with the court after we've ruled. If I have made a mistake in this case, you will appeal. If there is a conviction, it will get appealed to a higher court, and they can review it to determine whether or not I made a mistake. This is my ruling on this issue. You are free to communicate that to the jury in your closing argument. I am not instructing them on that. Moving on to the,
I would like, though,
moving on.
I'm not disagreeing. I would like, though, to move in limine at this time with regard to Mr. Della Rionda or Mr. Guy or Mr. Manti's anticipated closing argument to ask the court to order them not to suggest to the jury that following somebody on foot.
Okay. Do you want
or-
me to get into getting a predetermined transcript of what each side intends to argue at closing argument and go through it and say what can and cannot be argued?
ma'am,
They're
just-
free to argue that.
No, ma'am, just this, that it would be an improper argument of the law if the state were allowed to suggest to this jury that it is unlawful for someone to follow another individual by car or on foot. And
I'm not going to
for the
address
state to
that
be
issue.
allowed to make that argument would mislead the jury as to the law and would allow the jury to make a decision based upon an improper legal premise. because the state can't make that argument legally, and I'm moving in limine now for the court to preclude that specific argument. And I understand the court's ruling as to the instruction.
Okay, your motion in limine is denied. The next portion of the instruction is the paragraph, and I'm going off of the defendant's suggested instruction. It starts at, in considering the issue. There doesn't seem to be any objection or difference in that paragraph. Am I correct?
I believe so, Your Honor, and the next one as well.
Okay, and the next one is, if in your consideration of the issue of self-defense, it's a 3-line paragraph, there doesn't seem to be any differences. Is there any objections to that paragraph?
Not from the state.
No, I think that's the standard language now.
Okay, thank you. And then the last one is, starts with however. If from the evidence, it's 3 lines. Is there any objections from the state,
No, Your Honor.
from the defense?
Agreed, that's the standard language.
Okay, so I think we have, were there any other requested changes or additions to this instruction by the state?
As it relates to the justifiable use of deadly force,
Correct.
again, having already argued and simply relying again on the case of Johnson versus State, which is also in the packet regarding the provocation instruction, no, Your Honor.
Okay, any others being requested by the defense other than the ones I've already ruled on?
Within the justifiable use instruction?
Yes, sir.
No, Your Honor.
Okay, then the next one that we have, the defense has another one, you just included in your packet the state's proposed instruction on justifiable use, is that
I
correct?
did, just for comparison purposes.
Okay, thank you. Then there is a circumstantial evidence requested instruction from the defense. Is there any objection by the state?
There is, Your Honor.
All
I've
right.
provided the case of Wadman, W-A-D-M-A-N versus State, which is 757 second 655. It's a 1999 opinion from the 4th DCA citing to the 1981 opinion of the Florida Supreme Court in re standard jury instructions in criminal cases, 431 Southern 2nd 594. The instruction requested here by the defense has been eliminated by the Supreme Court. It was eliminated over 30 years ago. And the reason it was eliminated, as Wadman makes clear on page 2 of the opinion at the bottom, the Supreme Court deleted this instruction from the standard instructions, finding that where the jury is properly instructed on the standard of reasonable doubt, the circumstantial evidence instruction was confusing and incorrect. The court does go on to say that while the Supreme Court did not totally prohibit it, if the court in a particular unique case believes that it is necessary under peculiar facts to give, that a court could consider this as a special instruction, theoretically. However, they go on to catalog a litany of cases whereby the refusal to give such an instruction has been upheld. At the bottom of that page, headnotes 2, 3, and 4, a trial court should not give instructions which are confusing, contradictory, or misleading. And if I go beyond that for a moment, the court's opinion also issued an order on rehearing, which is found on page 3. And what the court said at the very end of the bottom of the second column regarding it is, read in conjunction with the portions of the instructions that intent is an element of a crime that must be proven beyond a reasonable doubt, there is little risk that the standard instructions will diminish the state's burden of proof. And so the state objects to this instruction. We agree with the 30 years of precedent that have concluded it is confusing and incorrect. We don't believe that this is anywhere close to the peculiar case warranting the court even exercising a discretionary decision to give it. And I'll stop there until I hear more.
Okay, Mr. West?
Yes, Judge, thank you. I actually remember when this instruction was part of the standards. As Mr. Manti points out, that was some time ago. And generally speaking, the position the courts have taken is that a specific instruction on circumstantial evidence is not necessary because of the other instructions that the jury gets in terms of how to evaluate evidence. and they're told about circumstantial and direct evidence, but circumstantial isn't defined very particularly. However, when a case is appropriate for it, it's clear that the law allows it. The Supreme Court could have easily said at any point in time, you can't give it. If you give it, it's error. They haven't done that. What they've done instead, what has happened since, if you will, is that if the court thinks it's appropriate in a given case, because of the somewhat unique circumstances of that case, it is entirely proper to give the instruction. So knowing that it is proper, in some cases, I'd like to speak for a moment about why it's proper in this case. Since if the court gives it, it's not error. If the court denies it, it's probably not reversible error, unless a reviewing court finds that, in fact, this is that case, the case where it's specific enough as applied that it should have been given. So that's sort of the standard that we're looking at. And here's why it's important in this case. First of all, in voir dire, Mr. Delarianda made a big deal, a really big deal, about direct evidence and circumstantial evidence. Getting the jurors to agree and to understand and to basically say, okay, circumstantial evidence is just as good as direct evidence. And we know it's not, actually. It's not as good as direct evidence unless it meets the conditions or the criteria set forth here in this special instruction that this jury would have to apply in this case. It must be, those circumstances themselves have to be proved beyond a reasonable doubt. The jury needs to know that when you're comparing circumstantial evidence versus direct evidence. They need to know from this court that the circumstances must be consistent with guilt and inconsistent with innocence, meaning if they have a fact that's circumstantial, that tends to prove something the state is claiming it supports, or it could be interpreted as establishing a doubt or something that the defense claims exists, then the jury needs to know that if they have to decide how to interpret that piece of circumstantial evidence, that before they can use it against Mr. Zimmerman, they have to believe that it is only consistent with guilt and could not be consistent with innocence. In other words, Mr. Zimmerman gets the benefit of that issue, whether or not it's consistent with guilt or innocence. They must find it, in that instance, consistent with innocence and give Mr. Zimmerman the benefit of it. And, of course, that when you connect up the dots, if you will, when you pile on all of these circumstances, they must be so conclusive that it can only indicate proof beyond a reasonable doubt of the guilt. If the circumstances are susceptible of two reasonable constructions, one indicating guilt, the other innocence, you must accept that construction indicating evidence. So indeed, of the circumstances of this case, which is all circumstantial, if you will, on the issue of intent, and frankly, a lot of it is circumstantial on the core issue of self-defense, even though Mr. Root said that George Zimmerman's conduct was objectively reasonable under the information that he had. The jury has to find, was his fear, did he reasonably believe that he was facing imminent great bodily harm or death if he didn't respond with force? They're going to have to get inside George Zimmerman's head. They're going to have to take what was going on in his head under those circumstances, apply it to their own common sense, to their own somewhat objective standard of what's reasonable and what isn't, and come up with a decision based on circumstantial evidence, whether under those circumstances it was reasonable, after being hit in the nose, after having his head smashed on the concrete several times and being held down on his back, whether it was reasonable for him to have responded to that force in the manner he did. So there is no other instruction, I think, that's as specific, as poignant, as appropriate to help the jury define how to help the jury analyze the evidence in this case than this particular instruction. It could not be said to confuse the jury. In fact, it gives them the guidance that they desperately need in a case just like this one. So, of course, while the court has discretion, the discretion should be exercised here to give this instruction. It's perfectly proper.
Judge, if that argument were correct, every case with a single bit of circumstantial evidence in it would get this instruction because there is some circumstantial evidence involved. Number one, that's not true. It's not the law, and it's the reason it was abandoned 30-some years ago and hasn't been given. I don't see a case relied upon by the defense here where it has been. Number two, this is, of course, not a totally circumstantial case because we have direct evidence in the form of the defendant's own statements, and there is direct evidence that the defendant shot and killed the victim. So there is no question that this is not a totally circumstantial case, which is, I would put it, the only way we even get close to thinking about giving this instruction. And if the defense's argument were correct, this instruction would be continued to be given every case where there is a single bit of circumstantial evidence. It's just not. And it's not for the reasons that are expressed in the Wadman case. Because it is confusing and incorrect. So, that's what the Supreme Court said about it. The fact that the Supreme Court has said, just like with any other special instruction, there are going to be cases where a court may think it is appropriate to give this, doesn't mean what Mr. West thinks it means. The Supreme Court prefaces every jury instruction opinion they issue with the idea that the court isn't saying this isn't ironclad forever that we'll never change our mind. Montgomery is a classic example.
Okay, I've heard enough argument.
Yes, Your Honor.
I'm not going to give the circumstantial evidence instruction. The next one in our packet was the plea of not guilty, reasonable doubt, and burden of proof, and yesterday there was an indication that neither side objected to that. Is that correct?
That's correct. This is a standard instruction.
Okay, and the next one was the date of the crime, and yesterday there was no objection to that instruction. Is that correct?
That's true.
The next one was venue. There was no objection yesterday as to that instruction. Is that correct?
Yes.
Weighing the evidence, yesterday we had discussed the 1 through 5 that are always given. The state had requested the one on inconsistent statement. Court indicated it would be given. It appears in the new one, the state is also requesting the instruction that whether the witness has been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify. Is there any objection by the defense?
It's my understanding that the state wants this because there has been some testimony that experts have charged money for their services, as opposed to suggesting that someone has been paid off or bribed in some way. Is that the focus of it?
It is that, whether the compensation was financial already or expected. I think Mr. Root said he hadn't finished a bill yet or something of that variety. But yes, that is the reason. Nobody's going to be suggesting anybody was bribed. But there was compensation.
Well, that's kind of an interesting issue because there were some witnesses who were asked or indicated that they, I hate to use this word, but some people sounded like they were giving infomercials. And I don't want this to be construed that the jury can consider that. I think it would be misleading in that context.
I understand.
Because what the intent of any of them to give that additional information doesn't have anything to do with the defense calling that person or the state calling that person.
I understand. Dr. DeMille, for example, is one expert that comes to mind. He actually had listed the exact amount that he was paid for his work and to be
Well,
here.
there's a special instruction given for expert witnesses that I think that is appropriate to cover this. I could see the danger of this one because of that
Just for clarification.
possible infomercial information out there, so I'm not gonna give it.
Thank you, Judge. Just for clarification, unless to be argued later, Dr. DeMaio has not been paid anything. He said what he was charging.
Well, experts are entitled to be paid.
Absolutely.
So we're not gonna give that number 6, so redo that the number 6 will be the inconsistent statement.
Yes, Your
Was there anything else about the weighing the evidence that either side had any objections with?
No, Your Honor, not from the state.
From the defense?
No, Your Honor.
The next one was the expert witness instruction, and yesterday there was an indication there was no objection from either side. Does that remain?
Yes, Your Honor.
Yes.
Defendant testifying, we said was not going to be given. The defendant not testifying, is there any objections to that instruction?
No objection.
State?
Not from the state, Your Honor.
Defendant's statements, yesterday there was an indication there was no objection to that instruction being given. Is that the same today?
It is from the state.
Mr. West,
Yeah,
you don't have to keep jumping up and down. You can remain seated.
Thank you,
You're
Judge.
welcome.
You know, I just caught something here, whether we're going to personalize these instructions too.
All of them.
Okay,
Everything will be conformity.
yes, no objection.
Rules for deliberation, yesterday there was an indication there was no objections to this instruction. Does that remain the same today?
Yes, Your Honor.
Your Honor, if I may, as to the substitution of the names, do you want that in the Title II, for example, the defendant's statements? The title
Everywhere.
of that, you want that to say George Zimmerman's statements?
Yeah,
Yes, Your Honor.
thank you. Then the instruction on notes, the indication yesterday there was no objections. Does that remain the same?
Yes, Your Honor.
Yes, Your Honor.
Cautionary instruction, no objections yesterday. Does that remain the same?
Yes, Your Honor.
Verdict, there was no objections yesterday. Does that remain the same?
Yes, Your Honor.
Defense?
Yes, that's fine.
Okay. And submitting the case to the jury, there was no objections yesterday. Does that remain the same?
Yes, Your Honor.
Agreed?
Okay. We have to talk about the felony murder, third degree. One of the elements for felony murder or the child abuse portion of the felony murder
Yes, Your Honor.
is the intentionally. I'm having an initial issue with that. Child abuse requires the defendant to have committed an intentional act.
Yes.
That's not alleged in your information.
Shooting is an intentional act. It's the same intent required for second-degree murder. Second-degree murder requires the additional depraved mind element, but I don't think it's argued that this was an unintentional shooting. The question is whether it was justifiable, but not whether it was intentional.
That's the issue that I'm gonna be looking at. I'm gonna give Mr. West some time to do that. Was there any objections to the manslaughter instruction as it is written?
No.
So the only one that I have to deal with and make a determination on is the felony third-degree murder. Can we then now look to the proposed verdict form?
Judge,
With
there
regard
is-
to the third-degree murder issue, Judge, of course, the court pointed out it's one of those historically Category 2, which means that it's discretionary so long as the evidence.
The state gets it if they want it, if the facts fit to it. It's not really a discretionary issue.
I disagree, but.
Okay, well, I'll cite you to, I think it's Johnson versus State.
in any event, I'll look at that.
I want to make sure I give you the right citation.
But it's clear that the state must convince the court that the unique facts of this
Of
case.
course, always the facts have to fit into it, and that's not the issue.
would-
The issue is whether or not, if the facts fit into it, do they get a second degree, second category 2 instruction?
There is the state's proposed special jury instruction regarding the definition of great bodily harm as well before we get to the verdict
Oh.
forms.
I'm sorry.
My understanding is the defense objects to that in its entirety, and obviously I don't intend to place it, if it is given, at the end, but we could discuss placement if we wish, if the court is going
Okay.
to permit
Let's
it.
get on the record to make sure. It states proposed special jury instruction number 1, defining great bodily harm, setting the authority of Chesnoff versus State, 840 Southern 2nd, 423, 50 CA 2003. The suggested instruction reads, great bodily harm in the context of aggravated battery means great harm is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises as are likely to be inflicted in a simple assault and battery. That would be if the court was giving the instruction on the justifiable use of deadly force that included the force of the felony being inflicted on the defendant. Is that correct?
Well, I don't agree necessarily just to that. I would agree that if the court is not going to give the issue about aggravated battery, that we might remove the phrase of aggravated battery. However, even the requested instruction by the defense discusses the concept of in fear of imminent death or great bodily harm. So I think the definition and the concept behind Chesnoff and Coronado and Gordon and Owens, all those cases cited here, is defining great bodily harm so that the jury has a frame of reference. So whether the court gives the state's requested additional instruction or only the defendant's
Let me see
instruction.
if I'm getting what you say right. You would take out in the context of aggravated battery
Yes.
and then put it in the defendant's version of justifiable use of deadly force after the paragraph, a person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself.
That would be a reasonable location, yes, Your Honor.
Okay, any objections?
Yes.
What is your objection?
Well, there are multiple. First of all, the context of the cases cited is not appropriate for the context of the definition the state seeks in this case. There is no definition in the justifiable use of deadly force instruction for a reason, because the Supreme Court decided it didn't need to be defined beyond that within the common understanding of those terms by the jury. The state is seeking to shift the focus away from what everybody knows is great bodily harm and why that's in the instruction. And the reason it's in the instruction is this: it's not that Mr. Zimmerman sustained great bodily harm or great bodily injury himself. That is a completely irrelevant issue in this case.
Where in your proposed instruction does it have a definition of great bodily harm?
It doesn't. I gave the language that the Supreme Court used. That's the standard instruction. The Supreme Court does not define great bodily harm in the standard instruction for justifiable use of deadly force.
But the state is saying that this authority, Chesnoff versus State, as previously cited, Coronado versus State, 654 Southern 2nd, 1267, Florida 2nd, DCA 1995, Gordon versus State, 36 Florida Law Weekly, D 2590, Florida 3rd, DCA 2011, which cites to Owens versus State, 289 Southern 2nd, 472, 2nd DCA 1974, and C period A period C period versus State, 771 Southern 2nd, 1261, 2nd DCA 2000, and when NGUYEN versus State, 858 Southern Second, 1259 First DCA 2003.
Has the court read those cases?
I just see the synopsis, I do not have those
Right,
cases.
and the synopsis is the one provided by the state?
Correct.
Yes, and it's not correct.
It's actually a quote, so.
No, these aren't self-defense cases. These cases don't deal with the definition of great bodily harm in the context of the self-defense instruction. For example, in Chesnoff, the 14-year-old victim was attacked by another, and he was punched, I guess, and kicked, and that he had swollen lips and a swollen head, so swollen that his mother didn't recognize him the next morning. The jury got the instruction of basically severe harm or great bodily harm, and the jury found Mr. Chesnoff guilty of that offense, based upon the very thing that Mr. Manti suggests should be trivialized in this case. That is misleading and not appropriate in this case. Likewise, to suggest to this jury by any definition of great bodily harm like this one, which frankly is legally wrong, and we object, would shift the focus of this jury not from what Mr. Zimmerman thought was happening, which is the standard the jury should apply, but to what actually happened to him. And it's a mischaracterization of the law, it's misleading, and this is just plain wrong for the jury to have, factually and legally. As the court is well aware, there are no injuries required whatsoever for self-defense. Mr. Martin didn't have to lay a hand on him if, indeed, Mr. Zimmerman reasonably believed that the use of deadly force was necessary to prevent the imminent commission of great bodily harm. Everybody knows what great bodily harm means when you're punched in the face and your head is smashed on concrete. The state's expert said there are at least 3 impacts on concrete by Mr. Zimmerman's head. That is Dr. Valerie Rao. There's no issue there. She said as much. She saw the bruising, the collection of blood under the skin. She saw the lacerations. Dr. DeMaio opined further, having seen additional injuries, further increasing the number of the minimum times that Mr. Zimmerman's head would have impacted concrete. What the state has been trying to do from the beginning is somehow shift this not to what somebody going through what Mr. Zimmerman was going through at the moment must have felt that when you have your head banged against concrete and you're screaming for help and the person beating you doesn't stop and no one's coming to help, that's a reasonable basis to believe that you're facing great bodily harm. Just because he didn't die, just because his skull wasn't fractured, just because he healed up relatively quickly doesn't mean that he didn't have that fear and that reasonable belief at the moment. The state is asking the court to deviate from the jury instructions with something specific that doesn't apply, that's not an accurate statement of the law or a definition that has been approved in self-defense cases. This is treading on very thin ice for this court. Very thin ice for the court under these circumstances to instruct this jury on something that just isn't the law.
Response?
Actually, I disagree. The standard jury instructions for any offense, self-defense, aggravated, anything, there is no definition anywhere. That's the reason the courts have given it. Self-defense isn't sort of some special circumstance. The fact is, the phrase great bodily harm is used in an instruction, whether it's in the self-defense instruction or whether it's in connection with another instruction isn't the point. The point is the court said, Chesnoff and Coronado and all these courts said, the standard jury instructions provide no definition of great bodily harm, and that's anywhere. That is the reason they approved the court giving the jury some guidance as to what that might be. I will first point out that Mr. West is not correct that any doctor said injury X must have come from getting your head, I think as he put it, hit on the concrete or mashed on the concrete. What they said was, it is possible, it is consistent with that happen, it is equally consistent with getting struck by any hard object, including a fist.
No.
That's, but please don't interrupt each other.
And-
But I'm gonna interrupt.
Yes.
You have to take each of these proposed jury instructions and the special instructions that are being requested by either side and weave it into what the evidence shows so the jury can be instructed. Your argument that you just provided to me has two different sides of the story. That's the jury can decide which one they believe, whether the injuries were consistent or they were not consistent. The instruction that you're seeking to have entered says that great bodily harm is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises as are likely to be inflicted in a simple assault and battery. The testimony before the court, whether the jury chooses to believe it or not, that's their purview, is that you don't have to have any injury to be in fear to the extent of the justifiable use of deadly force.
I agree with everything the court said, and that's why the argument wasn't quite finished. What we're talking about here is the defendant's reasonableness of his fear. If his fear is only that he's going to get a fist beating, for example, that is something that the jury should know in relationship to the definition of great bodily harm. In other words,
I
when
find this definition akin to what I've just stricken from the defense request, that they want me to instruct them that the Florida law is it's not illegal to follow somebody. I find this akin to that. So I understand your argument. You have it all on the record. I've cited the cases that you cited to me in support of them. They're on the record. Unless you have further argument about that, I'm ready to roll.
Well, especially, the only further argument I'll make on it is this, especially since I believe that we should include the aggravated battery sections as it relates before, especially since I think those should also be included. Most certainly, this definition should be included,
Okay,
Judge.
well, I've already struck those, so that's not an issue. Okay, the court is not gonna give that special instruction. So is there any other special instructions being requested by the state? Additions, omissions, anything?
The only other one was the provocation instruction under Johnson, where, because there's evidence in the record that Johnson may have initially provoked, that should be given. But those were the two, I think, that the state was requesting here, and then the aggravated battery definition. So
Okay,
that was it.
how about by the defense? Right, can we go on to the verdict form? Of course, the verdict form may need to be readdressed because of pending the court's ruling on the third-degree felony murder.
I don't have a copy in front of me, Judge, sorry.
Do you have an extra copy?
Are these the same that were submitted earlier?
Yes. They were the electronic version submitted this morning.
Well, I mean, before today.
Well, no, one of them is third degree.
All right, if I could have a set then of the
Yes, you may.
current ones, thanks.
Have you had an opportunity to review it?
Yes, it's a single verdict form that contains all of the possibilities.
Okay, so depending upon what the court's ruling is on the third-degree felony murder, you think that this verdict form is correct?
I don't like the form of it, and I have some requests in that regard, but I think legally it has the considerations that the jury must address if they find an offense to have been committed and that a firearm was used. Yes.
Okay, then what is your objection to the form? Because it's really not formatted correctly pending the court's ruling on third-degree felony murder and, because there's breaks in it,
I understand, but if the court were to say that you're not giving third-degree felony murder, we would simply remove the middle
That
page
page.
altogether, I think, and then it would,
right, so then what would be your objection to the form?
The verdict form is confusing. It's confusing because of the way that it's formatted. For example, it starts with, "We, the jury, find the defendant guilty of murder in the second degree as charged," and then goes all the way through the individual enhancements, if you
Okay.
will.
I have to agree with the defense on this, because every time I give this jury verdict form, we have the enhancements as a separate special finding. It could be, after the defendant is found not guilty, you could say, if you find the defendant guilty of the offense of murder in the second degree, you must further find, and do it that way, because I think there is a lot to get to before you get through the possible findings by the jury as to guilt or not guilt, or guilt of a lesser included.
we can do that. The only.
Okay, is that what your objection is?
Yes,
There
the
should be a
first line
special
can say,
finding.
"We find the defendant guilty of murder," and
No,
then the
I
second
understand.
line should say, "We find the defendant not guilty."
No,
And
it
then-
should, no, the way it should say, "We find the defendant guilty of murder in the second degree as charged in the information. We, the jury, if I so find, we, the jury, find the defendant guilty of third-degree felony murder, a lesser included offense." The next line would be, "We, the jury, find the defendant guilty of manslaughter, a lesser included offense," and then it should be, "We, the jury, find the defendant not guilty." That is how it has always been done by this court. Then there should be a section after that that says special findings, and the special findings should be the relating to the firearm. So that's,
I want not guilty on the first page.
I know you want that, and every
And-
defense attorney does, but it's not done.
Well, I'd like it in this case because all of the choices the jury has before they even see the place that says not guilty.
It'll all be on
There-
the same page.
Pardon me?
I understand your argument, but I'm not doing that.
And I think the order of the possible verdicts is also incorrect.
Okay,
So I'd like the court to address this, and that is that manslaughter is a category 1, third-degree murder is a category 2. So the logical choice would be, if the court's going to give those lessers, that the first one be murder, the second one be manslaughter, the third one be third-degree murder.
okay, is there any objection to that by the state?
No, we'll do it
Okay.
that way, that's fine. The only issue with that is we will then have to repeat, because the firearm findings for each of the murder counts are different than the firearm findings for manslaughter because of the 1020 life language. Now you're gonna,
1020 life doesn't apply to third-degree murder.
that's why
It does
Yes,
too.
yes, it does.
It even applies to aggravated assault.
yes.
Well, I'll have to,
It does apply. You'll just have to put it in a way that would make sense, but the court's
We can do
ruling
that.
is gonna be the charges be first, and then the special finding by the jury. Before we recess for lunch, let me give you a schedule thing. Yesterday, Mr. West, you had indicated, or I don't know if it was Mr. O'Mara, I'm getting into a housekeeping issue. You had sought to introduce into evidence Defense Exhibit Double D, and that was the portion of a tape played in front of Miss Gentile. And the court had indicated that my notes reflected that that tape was played to Miss Gentile outside the presence of the jury. And I asked the court reporter to check her notes, and the email that I got back was, in cross-examination immediately after lunch, Mr. West asked questions regarding the, quote, "You want that too," end quote, part of the tape. and that was played to Ms. Gentile outside the presence of the jury. When the jury was brought back into the courtroom, Mr. West used the transcript to question her on that issue. So the court will not be admitting Double D into evidence that was not played in front of the jury. As far as scheduling purposes goes, I know the jury's supposed to be back at 1. I know that Mr. De La Rianda wants to get the jury instructions settled before he does his closing argument. I'm going to say that we'll be in recess until 1 o'clock. I will take up the second-degree murder argument, and thereafter, Mr. De La Rianda will be given some moments to get his, but that would be the only thing he would have to plug into his closing argument, and we'll start the closing arguments for the state this afternoon.
I'm sorry, the third-degree murder argument, Your Honor?
The third degree, I'm sorry.
Thank you.
Manslaughter will be given.
Who's taking responsibility for finalizing the set of instructions?
Well, the state's going to do it,
Being done as we speak, Your Honor.
All right, and I'll be.
and we'll review them,
Okay.
okay?
And,
So we'll be back at 1 o'clock and be prepared to argue the third-degree murder instruction. I think all the other instructions have been resolved.
I will do my best. It's only an hour, and as I mentioned, this was all put on us this morning. I
Okay,
knew
I
nothing about it.
understand. I
Okay.
understand.
And will we have a chance to review the verdict form prior to?
Yes.
And is the state going to prepare the draft of it?
Yes, they are.
Thank you, Judge.
Would
Okay.
everyone like that electronically over the break as soon as it's completed?
I'll just take a hard copy.
Yes, Your Honor?
Thank you. Court will be in recess.